Dear, can you hear me? Okay, all right, thank you very much. I had difficulty unmuting. So dear ministers, ladies and gentlemen, good afternoon, good evening. My name is Elsa Piliszewski. I'm the Director for Public Governance at the OECD, and I will be the Master of Ceremony for the opening session today. I really want to welcome everyone to the Global Dialogue of Justice Leaders, Transforming Justice for a Vibrant Social Contract. This is really the centerpiece of the second Global Week for Justice, which is a series of events and meetings in support of countries' implementation of SDG 16. And I really want to thank Latvia for hosting and for their overall leadership on this event. We have been working on access to justice and people-centered justice for about 10 years now, and this has really become a core piece of our work at the OECD, and this will be a very strategic input into the Public Governance Committee's initiative called Reinforcing Democracy. And today is, of course, another landmark for this work with the launch of the Principles for People-Centered Justice and the framework with the knowledge that we have accumulated over the last decade in OECD countries and partners around the globe. I am delighted to present this high-level dialogue co-organized by the Ministry of Justice of Latvia, the Open Government Partnership, and the Pathfinders for Peaceful, Just and Inclusive Societies with the OECD. I thank them all for that. This high-level dialogue will have 3 sessions that will extend during the next 2 hours. And this year we are having over 20 countries represented. And for this opening session, there are 4 panelists that I'm delighted to introduce. First, Jānis Bordāns, the Minister of Justice and Deputy Prime Minister of Latvia, Matthias Korman, by video, the OECD Secretary General, Sarah Cliff, the Director of NYU Center on International Cooperation, representing Pathfinders for Peaceful, Just and Inclusive Societies, and finally, Joe Powell, Deputy CEO of the Open Government Partnership. But first, Mr. Minister, Mr. Jānis Bordāns, the floor is yours.
Ministers, dear ladies and gentlemen, good morning and good evening for those who joined us from the different parts of the world. And it is my pleasure to welcome all of you today for our virtual debate. Sincere gratitude for your time and opportunity to join. In July 2018, in the capital of Latvia, was adopted the Riga Statement, Investing in Access to Justice for All. Then, OECD member and partner countries and members of the Pathfinders for Peaceful, Just and Inclusive Societies met to highlight collaborative government and civil society efforts towards strengthening legal empowerment and people-centered access to justice. Participants of the debate called for continuous action in investing and in access to justice for all to foster inclusive growth and implement the 2030 Agenda for Sustainable Development. With a number of other documents and extensive work by OECD, Pathfinders, and the Open Government Partnership, the Riga Statement contributed to the global debate. It is a pleasure and honor for the Latvian government to co-organize the discussion today with the objective to shape the future of global cooperative justice. I would like to extend my gratitude to the partners and to Justice Canada leading the first global dialogue of justice leaders last year, I appreciate the opportunity to continue the debate on the crucial role of the justice system in inclusive recovery stressed by Justice Canada 2020. As stressed in the concept note that we shared with you under the leadership of Government of Latvia, this year Dialogue will aim to highlight priority actions and follow-up in facilitating people-centered justice for transformation and the adoption of open government principles across justice system, also in line with the commitment to the UN Common Agenda. In this context, we are also pleased to have the OECD framework and good practice principles on people-centered justice launched during this meeting that we hope will help countries deepen people-centered justice transformation. For me, as the Ministry of Justice, fair justice system and secure business environment are the priorities and cornerstone for the inclusive growth. In this regard, the Specialized Economical Court has been established in Latvia this year to concentrate expertise in commercial matters, corruption, and money laundering cases. Number of legislative initiatives are initiated and implemented to strengthen access to justice and trust. Among them, more transparent registration of beneficial owners in commercial register, low-income person release from a small debt, the comprehensive justice audit conducted to revise the cooperation between justice and law enforcement agencies, leading to the enhanced dialogue. Online dispute resolution concept is integrated in judicial service to raise an access to justice and reduce costs of litigation. This year, the trust to the justice system in Latvia among businesses has increased by 13%, among citizens by 10%. Let me come back to today's discussion and highlight a couple of elements for the debate. We have foreseen to focus our discussion on the necessity to transform the justice system to effectively respond to the current global circumstances. A lot of efforts previously have been made to shape the idea of people-centricity. We have exchanged the best practices through the recent years. However, with the impact of pandemic crisis around the world, and despite of the previous efforts and common understanding, we observe the disconnect between institutions and people, decrease of trust, and economical uncertainty. Thus, today we would like to call for the debate on ways to achieve a most profound changes in the justice sector. First, seeking approaches to be further implemented in justice sector to build capacity, use technology and data, as well as introducing new management approaches for better justice services. Second, to stress the importance to be more open and transparent. I want to mention that the nation level to the next OGP action plan for 2022-2025, we are integrating justice activities and looking for the opportunities to implement the open government principles to a broader extent in the justice sector. Third, coming back to a broader perspective, objectives and role of justice system in keeping the democracy strong. One of the goals of this high-level dialogue is the leaders can agree on an outcome document that can help to shape the justice policy debate in the coming years. We invite you to share the most practical examples possible, exchange on the future perspectives, and endorse the outcome document, Riga Justice Agenda, Transforming Justice for a Vibrant Social Contact. Thank you.
Thank you very much, Minister. And once again, we thank you for the leadership of Latvia in this very important field. Now, the floor is for Matthias Cormann, the OECD Secretary General, and who apologizes as he was unable to attend, but however prepared a short recording message that we'd like to share with you. Thank you.
Ministers, Excellencies, thank you, Minister Borden and the Ministry of Justice of Latvia for hosting the second Global Dialogue for Justice Leaders alongside our co-organizing partners, the Pathfinders for Peaceful, Just and Inclusive Societies and the Open Government Partnership. Nearly 2 years into the COVID-19 pandemic, we continue to live in extraordinary times. The largest health, economic and social crisis of our generation has caused severe consequences in terms of people's lives and livelihoods. Increased job dismissals, evictions, domestic violence, contractual disputes, and insolvencies generated by the crisis have translated into higher pressures onto our justice systems. While the recovery from the crisis has been fast and strong, we are projecting global GDP growth of 5.6% this year and 4.5% next year. It remains uneven across countries, sectors and households. And we risk leaving the most vulnerable behind in this recovery. The justice system is the fundamental cornerstone for fulfilling our society's shared values, our shared commitment to democracy, the rule of law, human rights, market-based economic principles, a global level playing field, and a rules-based international order. It also provides the key institutional underpinning for equal opportunities and economic growth, and will be essential to ensure that everyone has the opportunity to participate and benefit in a strong, sustainable and resilient recovery. The recent waves of social movements across the globe have revealed strong expectations over the transparency and accessibility of justice systems. They have also highlighted uneven trust in justice as the ultimate guarantor of people's rights, with the potential of also reducing trust in other public institutions and ultimately in democracy itself. This has highlighted the crucial need for a renewed social contract. To protect our justice system, we must rebuild trust between institutions and the citizens they serve. One essential aspect of this endeavor will be a reform of justice systems in line with Sustainable Development Goals, namely SDG 16, promoting peace, justice and strong institutions. I'm thus very pleased that we are launching the OECD framework and good practice principles for people-centered justice today. The framework and principles aim at supporting countries in implementing access to justice commitments and facilitating people-centered justice transformation to strengthen the responsiveness of justice systems. The framework and principles provide a comprehensive vision for justice systems that is people-centered and integrated across sectors. They also showcase good practice examples for achieving equitable and people-centered justice. Let me focus on 3 key messages from this work. First, leadership is crucial for the implementation of a people-centered approach across the justice sector. Leaders like yourselves can set the vision for justice reform and ensure that policy decisions for the justice sector are truly people-centered. And leaders have an important role to play in promoting a whole-of-government culture in which all parts of the state and stakeholders work together to close justice gaps. Second, legal innovations have a strong potential to increase access to justice when put to the service of the people. The crisis has spurred such innovation, including the use of digital tools, simplified procedures, and more effective dispute resolution mechanisms. Third, the use of data is an incredibly important tool to enable access to justice, to support both evidence-based policy making and adequate monitoring and evaluation of the system's performance. Better access to justice data, including understanding the legal needs of people, can help governments in designing and delivering the right services more efficiently, identify new or rising needs, and develop foresight capabilities. The response to the COVID-19 crisis has shown that decisive and coordinated action can make a real difference in addressing global challenges and in ensuring better outcomes, not only in economic terms, but also for citizens. I therefore encourage you, as justice leaders, to keep working together to ensure that the justice system serves people's needs and protects their rights. The OECD remains ready to continue to support you in this endeavour, including through platforms for international dialogue, such as this one, and by developing further policy tools building on the framework for people-centred justice. Thank you.
Thank you very much for Secretary General Corman, and thanks to OECD colleagues that played the video. I now want to pass the floor to Sarah Cliff, representing Pathfinders for Peaceful, Just and Inclusive Societies. Sarah, the floor is yours.
Thank you so much, and I'd like to thank the Ministry of Justice of Latvia for hosting the meeting, along with the OECD and our partners in the Open Government Partnership, as we gather together here for the second week, Global Week for Justice, and the second Global Dialogue of Justice Leaders. It's very heartening to see the movement from Justice for Justice continue its momentum, as seen by all those gathered today. What we are seeing around the world, though, is not so heartening. We are seeing a fraying of the social contract, increasing protests, societal tensions and polarization, a growing disconnect between people and the institutions that are meant to serve them. Justice actors are often in the front line of people's grievances. They have an important role to play. They can contribute to strengthening the social contract, or their actions can harm and undermine it. Similarly, many people feel frustrated and left behind and do not see the system working for them. They are disenchanted with democracy because they do not feel it's delivering, as Deputy Prime Minister Bordans referred to in his remarks. They don't see that it's creating meaningful results in people's lives. And in the area of justice, they are not wrong. 5.1 billion people around the world do not have meaningful access to justice. So putting people and their justice needs at the centre, as is being done through the OECD principles and through the Riga statement, is critical to restore the relationship between people and government. The global movement for people-centred justice is designed to address the urgency of these challenges. We also know that results have to be achieved at the national level, at the coalface, as it were. And this is why it's so powerful to see national leaders coming together on this global platform to learn from each other, to share evidence and commitment in the pursuit of justice for all. Building on the work from the OECD, OGP and the Pathfinders Task Force on Justice, we will continue to support national action that puts people at the centre of justice and helps us achieve SDG 16's promise of equal access to justice for all. We thank again our partners and hope that everyone participating enjoys the discussion.
Thank you very much, Sarah. I am now absolutely delighted to pass the floor to Joe Powell, Deputy CEO of the Open Government Partnership.
Thank you so much, Elsa. I'm delighted to be here, and big thanks again to the Minister and the Ministry of Justice of Latvia for initiating and hosting this dialogue, and all of our close partners at Pathfinders and OECD. This topic is of vital importance to the Open Government Partnership. It's a real pleasure to see many of our member countries and civil society leaders here today. When we met last year as part of the first Global Week for Justice, we were focused on the impact that the pandemic was already having on our societies, and specifically the increase of an already pre-existing justice gap, and that link to inequality in our societies. As the other introductory speakers have already referenced, we now have some experience of what needs to be done in our country's justice systems to better respond to the ongoing challenges that we all face, but also to prepare and strengthen justice systems for future crises. This year, we're also meeting before two major global summits on the importance of democracy and open societies. After 15 consecutive years of decline of civil liberties, really worrying trends on trust in government that Sarah mentioned, and many countries sadly backsliding on democracy, these are really vital political moments that we need to maximize as a group of justice leaders. The US hosted Summit for Democracy later this week will bring countries together to tackle some of the frontier issues threatening democratic progress, such as kleptocracy, as the minister mentioned, anti-money laundering, attacks on freedom of speech, and declining civic space. And next week, the Republic of Korea will host the 10th anniversary Global Summit for the OGP, where 78 countries will be gathering to share their experiences on what specific reforms help to strengthen democracy and open societies. And the reason I mention this is because without access to justice and without open justice systems, democracy cannot deliver for people. Our justice institutions are the very symbol of what the state needs to do when people have nowhere else to turn. And we know that the vast majority of people's justice problems have to do with things that are most important to their everyday lives, from health, education, housing, employment, and so on. And that's why this is such a fundamental issue for the social contract and for ensuring people trust that they will get what they need and what they are entitled to from their government. So what can we do today as justice ministers and justice leaders? One dimension that at OGP we're obviously encouraging is that justice systems embed the values of transparency, public participation, and accountability. We have a growing coalition of justice leaders represented here today, and I really look forward to hearing from many of your experiences and specific reforms your countries are working on. At OGP, we're ready to work with all of you after this dialogue to see how we can work together to implement these reforms and to showcase them as part of this better version of democracy and governance that citizens are rightly calling for. Thank you.
Thank you very much, Joe. And we're already into the substance. And I would like to thank Minister Bordans, Matthias Corman, Sarah, and Joe for their important remarks that put us right in the center of our topic. I'm now delighted to pass the floor of moderation to Minister Bordans, our dear host. And I look forward, of course, to hearing all of our distinguished panelists today. Thank you very much.
Thank you, Elsa. Thank you very much. But before I open the floor for the discussion in our first panel and invite panelists to speak, please let me highlight the importance of people-centered approach to be introduced in justice system to help restore the trust between the people and public institutions. The OECD today is launching the OECD framework and good practice principles on people-centered justice. To help frame the discussion, I want to briefly mention the core pillars of the people-centered justice that are proposed in this document, that were built based on the international experiences. The first is the foundation of the framework, which emphasizes leadership for promoting people-centered purpose and culture. Then are the key pillars of the framework, which include design and delivery of people-centered services to make them more appropriate to the actual problems individuals are facing, and knowing what works for vulnerable groups and foster their inclusion. The pillars also include governance enablers, which concerns to cross-sectoral coordination measures and procedures to design and power better justice services. People empowerment and planning, monitoring, and accountability, including the importance of evidence in understanding legal needs of different groups of people. The framework and principles aim to provide a roadmap for countries to drive people-centered justice reforms. It would be important to further strengthen this work, possibly going towards an OECD instrument, which could be accompanied by implementation tools and indicators to further assist countries in this area, which is crucial for recovery and deepening our democratic values. Before we start, I want to do a brief mention on timing. Our panelists are each expert in their fields and country representatives of the highest level. I believe they could easily talk about the topic of the session almost all the day, but we only have a limited time and many justice leaders to highlight their work. So the organizers have asked me to keep the eye on the clock and be very strict in enforcing the parameters of interventions. So I would like to remind all panelists to please keep their interventions to 3 minutes. With that, let's turn to distinguished panel. And it is my honor to provide to Mr. Demerjiev, Minister of Justice of Bulgaria.
Благодаря, господин министър. Уважаеми колеги, книгата си «Цивилизацията» на въпроса какво е цивилизация, историкът и писател Кенет Кларк отговаря: не знам, не мога да я дефинирам, но ще я разпозная, когато я видя. Тази констатация несъмнено може да се възприеме и по отношение на понятието, което следва да стои в основата на правосъдните ни системи – справедливостта. Всъщност едва ли е случайно, че в множество езици думата за справедливост и за правосъдие е една и съща. В основата на правосъдието са хората и справедливото решаване на техните проблеми, което от своя страна трябва да има за начална точка принципа на върховенството на правото. Именно то е основната обща ценност, която обединява демократичните държави. Законността, правната сигурност, ефективните правни средства за защита и съдебен контрол, разделението на властите и равенството пред закона имат пряко въздействие върху живота на всеки гражданин.
Thank you, Minister. Colleagues, in his book, Civilization, Kenneth Clark, a historian and writer, asks the question, what is civilization? And then answers, I don't know, but I can recognize it when I see it. This finding undoubtedly can be deemed valid in terms of the concept which is the underlying concept of our justice systems, and that is fairness. In fact, it is hardly coincidental that in many languages, the word for justice and fairness is one and the same. At the heart of justice are people and the fair resolution of their problems, which on its part needs to start from the principle of the rule of law. The rule of law principle is the key common value that unites democratic societies. Legality, legal security, effective remedies, and judicial review, division of powers, and equality before the law have a direct impact on the life of each citizen.
Последните 2 години върховенството на правото и независимостта на съдебните системи бяха изправени пред предизвикателството на пандемията от COVID-19. Тя изведе напред спешната необходимост от постигане на цифровизация на националните правни системи. Качественото функциониране на съдебната власт по време на криза е от решаващо значение за защита на тези основополагащи принципи. Същевременно бързото навлизане на новите технологии следва да бъде съчетано с гаранции за спазване на основните права на гражданите.
Over the past 2 years, the rule of law and the independence of judicial systems faced the challenge of the COVID-19 pandemic. It brought forth the urgent necessity to achieve digitalization of the national judicial systems. The high quality functioning of the judiciary during a crisis is of key and critical importance for the protection of those founding principles. At the same time, the quick penetration of new technologies should be combined with safeguards for respecting the fundamental rights of citizens.
България си поставя за цел цялостна дигитализация на съдебните производства до 2026 година. Стремежът ни е да се гарантира максимална степен на прозрачност, бързина и ефективност на всеки етап от съдебното производство. Това ще повиши отчетността на съдебната власт и ще доведе до повишаване на доверието на гражданите и бизнеса. В България вече действа единна информационна система на съдилищата, както и единен портал за електронно правосъдие, а видеоконференциите се прилагат широко, както в гражданските, така и в наказателните производства. По този начин ще се гарантира достъпа до правосъдие да бъде осигурен за всички, независимо от тяхната възраст, раса, произход или социална група. Използването на цифрови технологии все пак трябва да остане допълнителен подпомагащ инструмент и да не замества стандартните процесуални гаранции за тези, които нямат достъп до новите технологии.
Bulgaria has set out to achieve full digitalization of legal proceedings by 2026. Our aim is to guarantee the highest level of transparency, rapidity, and effectiveness of each stage of the legal proceedings. This will increase accountability of the judiciary and will increase also the trust of citizens and the business. Bulgaria has already implemented a unified information system for the courts and a unified portal for electronic justice, and the video conferencing is widely used in both civil and criminal proceedings. Thus, we can guarantee that the access to justice will be provided for all people, regardless of their age, race, background, or social group. However, the use of digital technologies still has to remain an additional supporting instrument and not replace the standard procedural safeguards for those who do not have access to new technologies.
Обмен на мнение като днешния показва, че въпреки различните конституционни и правни традиции, съществува реална необходимост от общи действия между нас. Те биха ни помогнали за преодоляване на предизвикателствата на съвременното общество, породени от бързото технологично развитие и за намиране на практически решения. Така заедно ще работим за ориентиран към човека подход, който защитава съществените елементи на правата на човека, демокрацията и върховенството на правото. И в дигиталния свят. Именно това е подхода, който трябва да бъде в основата на добре функциониращата и ефективна съдебна система.
An exchange of opinions like today's shows that despite our different constitutional and legal traditions, there is a real need of common action between all of us. This will help us overcome the challenges of modern society resulting from the fast technological development and find practical solutions. In this way, we can work together towards an approach, people-oriented approach that will protect the key elements of human rights, democracy, and rule of law in the digital world as well. That is the approach that should be at the core of a well-functioning and effective judicial system.
Убеден съм, че дискусиите по тези важни за правосъдието теми трябва да продължат. Така ще се насърчи и по-нататъчното сътрудничество на държавите ни чрез споделяне на най-добри практики. А в заключение бих искал да ви информирам, че, както знаете, наскоро в България се проведоха парламентарни избори и формиращото се ново мнозинство поставя за свой приоритет съдебната реформа, така че ние имаме надежда, че тя ще се случи по възможно най-бързия и ефективен начин. Благодаря ви.
I'm confident that the discussions on those important topics for justice should continue. In this way, we will encourage the further collaboration between our countries through sharing best practices. And to conclude, I would like to let you know that we very recently had parliamentary elections in Bulgaria, and the new majority that has been formed now has set as a priority for their governance the judicial reform, which gives us hope that this reform will be implemented in the fastest and most efficient manner. Thank you very much.
Thank you very much. And now I would like to invite Mr. Fernandez Minister of Justice and Human Rights of Chile. Please.
Muchas gracias. Muy buenos días.
Thank you very much. Greetings to everybody. Ministers of Justice who are participating in this global dialogue of justice leaders. We thank the host, the government of Latvia. We thank the OECD, the OGP, and all of the organizers, the Pathfinders for Peaceful, Just and Inclusive Societies. I'd like to stress the importance of the modernization of our justice systems, which need to be people-centered, a new concept in access to justice. People need guidance, need a lawyer, and need to be able to rely on fair process. The current situation of access to justice is one where we need to situate people at the heart of the process so that people can fully exercise their rights. We need to open legal services, but also justice services, using various alternative methods for dispute resolution. And so these are the key ideas that need to inspire the transformation of our justice systems, we believe, if we are to open them up to center them on our citizens. In order to do this, Chile has made a very significant step forward in presenting and creating a national service for access to justice and for solidarity with the victims. We have set up an integral center. It's not just a judicial center, but it has psychological services, it has social workers, it has other kinds of guidance and assistance to help people to make effective use of the justice system where they find themselves in contact with it, so that they are oriented, supported, and guided through the process. We have been thinking of the need to have a national plan for access to justice, to really focus on intersectoral contact in order to make sure that we have a center that will fulfill all of these requirements. So we ran a diagnosis on the basis of a study that we conducted which was published in November, and that related to an assessment of access to justice in Chile. We worked on a public-private partnership basis to study the existing forms of legal assistance and how we could improve and consolidate in order to focus our services more on the need to focus on citizens in order to fulfill our mission, providing all of the alternatives to our citizens possible to achieve, to meet their needs. We worked with the Public Governance Directorate here at the OECD as well, running a survey on the judicial needs of the citizens, which is something which is going to reinforce our efforts to reform the justice system. We have a document which is called Legal Needs Survey and Access to Justice. And we believe that with these various tools, we're going to be able really to make progress in this program, and ensuring interdisciplinary and intersectoral cooperation to provide services that truly serve our citizens, rather than the other way around, having our citizens who are at the service of the state. We need to overcome the bureaucratic mentality that tends to operate in our societies in order to do that. So, very important that the various stakeholders in the justice system situate people at the center of their efforts, at the center of their service provision. We need to talk about approaches that are people-centered. We need to overcome the idea that our justice systems take legal requirements as their foundation, and instead turn that around and make it people at the foundation, to really be able to generate solutions that are effective, not just procedurally appropriate, but that are effective to meet the needs of each person who encounters the justice system, not paying lip service to these ideas, but really implementing them in an effective way, making sure that the state focuses on this requirement, that we have supervisory mechanisms with indicators of effectiveness, with the publication of data that enable us to ensure accurate follow-up and monitoring and ensure that the administrative guidance is followed to achieve our objectives. We really need to now move into action, move from speech to action to make progress in reality, change culture, work in an interdisciplinary and intersectoral manner, centering people at the heart of our system. Thank you.
Many thanks, Mr. Fernandez. And now I turn to my Italian colleague. It's my honor to invite to speak Ms. Cartabia, Minister of Justice of Italy. And so please, if you could share with us what is the situation in Italy regarding people-centered justice? I know from your experience, your very rich experience in justice field as a judge and as a lawyer. So could you help us and explain that?
Thank you, dear colleague. Thank you, and hello, everybody. Thank you for giving me the opportunity to share some thoughts about the concern about a more people-centered justice in Italy. When I was thinking to this panel, I asked myself, what do people expect from the judicial system? And in fact, this is the question that I'm asking myself since I took office as a Minister of Justice. And my answer is that the fundamental qualities of justice in citizens' eyes are credibility, reliability, trustfulness. People indeed expect judges to be fully independent, competent, autonomous. They expect that their procedural rights and guarantees are fully respected and that the judicial decisions are accurate and well-reasoned. But they also expect a timely response. They expect effectiveness. They have to have a right to access to an effective justice. Time and efficiency are essential components of a credible and reliable judicial system. These are the core inspirational design principles in the entire package of strategies and policies that we have adopted with this government. We have undertaken a huge and vast project of reforms aiming at more timely, reliable, effective justice in Italy. I would like just to mention some title of the major transformation that we are undertaking, because we are really a limited span of time. First of all, the use of technology and digitalization. The criminal procedure, digitalized criminal procedure was launched, virtual hearings rooms are installed, an e-learning platform was implemented to empower and follow up staff units in all territories and across the different levels of the administration and jurisdiction. We have learned so much from the pandemic. We understood that we need digitalization. The digitalization of civil procedure is already implemented in the 3 levels of jurisdiction, but we have to complete other parts that are still working on papers. Second, we had a major change in our system. We have introduced the so-called office for the process. That means that in every judicial office, there will be a team of junior legal experts. You can call them judicial assistants or clerks. And this implies that judges will work in teams. This is something new. Usually judges work as individuals. So we are shifting the paradigm from an individual work to a teamwork so that the capacity of work can be multiplied. This week we have recruited, completed the recruitment of some 8,250 junior legal clerks to be introduced in our judicial offices. Third, we had approved in Parliament 3 important reforms: the Criminal Procedure Act, the Civil Procedure Act, and the Insolvency Law. The 2 procedures were meant to simplify the procedure in order to have shorter processes. And also we wanted to encourage alternative dispute resolution, the ADR, but also restorative justice in the field of criminal law, and also punishment alternative to jail. In these reforms, we paid a lot of attention to family law because we have so much family cases and controversies. We have reorganized all the system of family law cases. And we have also changed the insolvency procedure because the pandemic has shaped a new panorama in which all the businesses are working, and we want to let those who are producing value in our society to have another opportunity to live on this difficult time of the pandemics. As to the methodology, this is another very important point. We wanted to engage with all the scientific community, but also with all the stakeholders, a wide and rich dialogue in order to elaborate in a shared way the new procedure, the new reforms that we are working on. And indeed, this is the polar star of our reforms is to fully implement our constitution, which is so rich as far as judicial activity is concerned. Last point, we are working very hard, and that is the reason why I have to leave you just after my intervention here. Would you like to excuse me for that? But we have to finalize another important reform, the reform of the High Judicial Council, which is very much expected in order to enhance the reliability and the credibility of our judiciary that undergoes some difficult time in recent months. Thank you very much for listening to us, and I very much to hear again from you and for the result of this meeting through the proceedings that will be delivered. Thank you so much.
Thank you very much, Ms. Cartabia. Thank you very much. And I know that my colleague, my Romanian colleague, has to leave our meeting for the Parliament for emergency. And please let me invite Mr. Marian Predoiu, Minister of Justice of Romania. And please, Mr. Minister, floor is yours. And could you really say what are good practices and initiatives being implemented by the country in the area of people-centered justice?
Thank you very much, Mr. Chairman, distinguished attendees, ladies and gentlemen. It is indeed my great pleasure and honor to address you in the context of the Global Justice Week. As we speak, the realities around the world undergo significant political, social, or economic transformation. The COVID-19 crisis revealed clearer than ever the deep disparities and structural inequities that marginalize large portion of society, making a true challenge out of the concept of justice as fairness described by John Rawls 50 years ago. The restrictions required by the pandemic affecting a significant number of human rights, the lack of prompt reaction or the inability to manage certain emergency led to the destabilization of public confidence worldwide, with undeniable effects on the convention that underlies each society, the social contract. The judicial reform must be strengthened by sufficient investments. The efficiency of the judiciary depends equally on the proper logistics of the judiciary. Without adequate court offices, modern computer applications, digital equipment, modern criminal investigation equipment, adequate staffing and expertise and adequate remuneration, a judicial system cannot be effective in enforcing the law, protecting the rule of law, and providing a quality public service with a reasonable time and at an appropriate cost. At the same time, an optimal justice system means a body of well-trained professionals. The legal, moral, and psychological training of magistrates is one of the key aspects of ensuring the respect and soundness of the rule of law. In addressing the elements that strengthen the role of justice as guarantee for a solid social contract, we cannot ignore the challenge of corruption. In all parts of the world, distrust in the state's institutions is fueled by people's experience of corruption. In this regard, targeted and proactive policymaking with an emphasis on preventive measures built on the successes of the past, whilst making the most of the new research and tools to protect the public, can lead to sustained reductions in grand or small corruption acts. Continuing its tradition in fighting this phenomenon, Romania is currently in the position to continue a strong response to corruption. Likewise, we are in the process to adopt the National Anti-Corruption Strategy for the next years, designed to achieve a tool adapted to current challenges and social realities. The substantiation of the new strategy had a multi-pillar approach, combining scientific sources, conclusions derived from an independent external audit, and from the monitoring reports of the old strategy. Identifying in due time barriers for some categories of persons to have access to justice in times of pandemic will allow to create a system accessible to all. A large numbers of unresolved justice problems can affect economies, may exacerbate inequalities, and can fuel even different forms of conflicts. In Romania, the use of electronic means was extended, especially video conferencing, in all courts trials. In criminal matters, priority was given to the files containing preventive or protection measures for victims and witnesses, those related to the medical safety measures, those involving juveniles, and some other urgent cases. Some of these measures continue to be applied today, when the rules of the medical alert are enforced throughout the entire territory. It is our preoccupation to identify the problems affecting the justice sector, to modernize justice institutions, and using the technologies and innovative solutions to help people meet their needs in accessing justice, providing real access to it. It is our duty to find solutions, even in this difficult pandemic context, so as to ensure that the social contract is respected, reinforcing at the same time democratic values. Recalling that the 2030 agenda is based on a vision of a just, equitable, tolerant, open, and socially inclusive world in which the needs of the most vulnerable are met, I believe this forum is a good opportunity to share successes and solutions in this common effort, and I thank you for the chance to be part of this collective effort. Thank you very much indeed.
Many thanks for stressing these important elements. As for next speakers, please let me ask Mr. Lewis, Minister of Justice and Governance of Malta. And please let me ask you to share experience of Malta in relation to the strategic approach to access to justice and your vision.
First of all, thank you for the opportunity. Thank you for the floor and for this initiative. As my colleague said, the justice system, which is people-centered justice, has to satisfy two important requisites. First of all, access to all, especially to those that don't have the necessary financial means to access justice. Secondly, a system with the necessary checks and balances to be held accountable towards the people. As the Italian Minister Cartabia said, there are three requisites for a good justice system: that is independent and impartiality of of the judicial bench. Secondly, quality, that is motivated, highly motivated judgments, where people get satisfaction from the justice system, even when they win or when they consider themselves as losers in such a system. Thirdly, efficiency. As we say, justice delayed is justice denied. So efficiency should be at the core as well of what we do. Malta has undergone extensive reforms in the last 20 months, reforming dramatically the system of appointment, discipline, and removal of the judiciary, wherein we remove totally the interface with the politician, with the executive, and the judges and magistrates are judged by their own peers and appointed by their own peers. We introduced new checks and balances with regards to our Attorney General, separating the function of the public prosecutor from the counsel to government. We devised a system of how we appoint, a more transparent system of how we appoint our police commissioner, gave more powers to our president, who were coming from a prime ministerial system, an English system, but we went into a process of sharing of power, and a lot of other constitutional and institutional reforms. However, we gave very big importance to technology. I believe that technology should never substitute the judiciary, but should help the judiciary in their work in increasing their efficiency. Technology should help as well our citizens to access justice. And that is where we have to educate more and create more awareness. Technology will help us as well in more judicial cooperation amongst us. We have just launched a digital justice strategy, taking us from 2021 to 2027, apart from already transforming all our court halls in fully technological court halls, in making all our judicial acts that can be filed online, scanning of all judicial documents, a lot of initiatives. But I believe that, to conclude, technology, if technology is used well and puts the citizen at the center, the sky is the limit, even vis-a-vis not only access to justice, but more judicial cooperation among states. Thank you very much for this privilege and opportunity.
Thank you very much, Mr. Lewis. And next, I turn to Belgium. Ms. Van Kouteren, representing Federal Public Service of Belgium. Could you please share your observation?
Merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Chairman. I'd first and foremost like to apologize on behalf of the director who was supposed to take the floor, and he apologizes. And so I will replace him, and I'll try to do that to the best of my ability. We need to develop a legal system that's centered on citizens and that leaves no one by the wayside, in particular the most vulnerable. This is, of course, a global concern. And we can see this in the different interventions today. And the Commission for the Efficacy of Justice will soon be convened, and the President of Belgium will attend, and he will continue to support also the work of the OECD. And he will support the agenda that has been proposed on the basis of the Riga Declaration. Mr. Jensens intended to mention some features linked to our national strategy. Of course, in 3 minutes, it's very hard to do this. And so basically, we started digitalizing our system. This, of course, was because of the pandemic. And digitalization and video conferencing were used in courts, as well as the legal aid officers and in prisons. This was done very quickly, of course, because of the pandemic, and the sound has just been cut.
Si la numérisation rapproche et qu'elle permet une meilleure communication.
Digitalization brings people together and enables better communication. At the same time, it can also aggravate the digital divide. Our president and our department are very aware of this. And that's why on the 30th of November of this year, a seminar was organized, and this question was raised and dealt with in a very cross-cutting manner. We brought together the representatives of the three constitutional powers, lawyers, representatives of associations, and of academia. And we thought about the issue of digitalization in relation to social inclusion. Our Minister for Justice, Mr. Vincent van Quickenborg, says that justice must be something that is open to all. Rapid and effective justice cannot allow itself to leave anybody behind. And this is something that involves several dimensions. It involves the procedural dimension. Everybody ought to have access to a court, to a judge. It also involves the dimension of equality. Everybody needs a fair and equitable trial. And then an institutional dimension. Our judges, our lawyers, and other stakeholders in the social sector need to talk together to find a way to ensure that the most vulnerable in our societies have effective access to justice. In this regard, Belgium has undergone significant progress. We had our judicial reforms, both in the first lines, the front lines, and in a secondary capacity. We have legal assistance and aid provided to people through an integrated approach that brings together the social services and the judicial sector to help the most vulnerable groups in society. I can't give you all of the examples because I don't have enough time. Another significant example, an emblematic example, is our work on the role, on the place of the victim. Our system recognizes the place of the victim in the justice system, and we are aiming to render services more human, closer and more supportive. We have assistance for victims, and we are developing a series of measures to better take into account the needs of victims, dealing with their cases in a more appropriate manner, working on the implementation of sentences, and also creating victim coaches for support. We're working with our police and judicial services, particularly with regard to dealing sympathetically with victims of sexual abuse and domestic violence, with dedicated services trained in these particular issues. Ladies and gentlemen, you see here a few brief examples of a major process of reform that we're all involved in at our own levels around the world. I will conclude my intervention by mentioning that our department, in collaboration with the Department for Social Integration, at the beginning of 2022, will publish a book entitled Justice est convoquée, and we will organize a study day on this subject. So this is something that we're really looking forward to. Thank you very much to your attention on behalf of Mr. Jean-Paul Vincès, who is the chair of our Justice Committee in Belgium. Thank you.
Yes, I just can agree that digitalization has the great potential in justice sector. From my side, I would just add that cannot be an inappropriate manner how to use digitalization. Well, it's we can use paper and say if we use appropriate manner, but also we can use digital tools And that's only the tools. Of course, it's the issue that we will discuss for further. Thank you very much indeed. And at this stage, please let me provide the floors to Ms. Vrtovec, State Secretary, Prime Minister of the Prime Minister Office of Slovenia. And what are the strategies being used by the country to put people at the center of justice system? Yes, please, floor is yours.
Hello, dear chair, dear distinguished guests and panelists. Thank you for the invitation. It is my honor to be able to participate in this conference with a very important topic. As the last one in this session, I will not focus on the individuals that seek justice in courts, nor will I focus on the judges that apply the law in individual cases. I want to emphasize the third essential aspect for transforming our justice systems for the better. This third aspect is the scope of our legal systems. I ask myself whether the people that we put in the center of justice really know the boundaries of the legal order they must live by. If they find the legal order vast and infinite, then putting the people in the center might not be enough to achieve the goal of this conference, for people might still feel like they are lost in legal space. If we truly want to empower people in relation to the justice system, then we should strive to limit the size of the legal order and precisely monitor when particular legal provision enters into force and when it goes out of force. We are faced with hyper-regulation in all areas of life that causes the information abundance of legal norms. In Slovenia, for example, we had more than 30,000 executive regulations in force last year. Therefore, it is, in my view, becoming increasingly important not only to enact laws, but also to repeal them when they are no longer in use. Only if we manage to keep our legal order up to date, vibrant, and lean, the people can fully appreciate what the rule of law actually means. For me, it means that outside legal order, there is still a place for individuals' freedom, since we, the people, are not institutions and are free to do anything that is not explicitly prohibited by law. In Slovenia, we started addressing these issues last year in the newly founded Strategic Council on Debureaucratization within the Office of the Prime Minister, where I work. In cooperation with the ministries, we analyzed our legal order and found that more than 200 laws and more than 20,000 executive regulations are no longer in use. They will be repealed. We also plan to establish the official registry of the Republic of Slovenia as the digital codification of the Slovenian legal order. The registry will organize the entire state legislature not only by chronological order, as is the habit in official journals, but hierarchically and thematically. We plan to facilitate people's access to official and trustworthy content of all the valid legal provisions, as they will be changing over time. Let me finish with an invitation to all of you that also find the ever-increasing scope of our legal orders problematic. Please share with me your ideas on how you tackle these problems. It is my vision that by the 1500th anniversary of the Justinian Code that served as the basis for all the Western legal systems, we could together develop a unified digital application. The countries around the globe could use this application if they wanted to digitally codify their legal orders in a harmonized way. Thank you for your attention.
Thank you. Thank you very much. I want to thank all participants of this panel for such a stellar presentations. But before I pass the floor to Joe Powell, Deputy Chief of Open Government Partnership, to start the second session, I would like to ask all the speakers of the session of for the family photo. So thank you very much. I believe the family photo has been taken, and now we can turn to next issues, and I give the floor to Joe Powell.
Thank you very much, Minister. I hope the photo was taken okay, although sadly, I think the Minister from Malta, who had a very nice Christmas tree, I couldn't see his camera, so hopefully we can add that one later. Thank you so much, everybody, for joining. We are now going to shift the conversation from the people-centered approach to embedding open government principles across the justice system. And we have a diverse group of speakers who have agreed to share their experiences from a further set of countries, looking at how justice systems can improve on accessibility, transparency, and accountability, and improve service delivery. We are running behind, so please do try and keep to the 3-minute time allotment. There is a slide that comes up when you have 30 seconds remaining. When you see that slide, please try to begin to wrap up your intervention, and then we can make sure everybody has a chance to speak before we close the meeting. So I would first like to turn to the Minister of Justice of Albania, Mr. Oecd Maynard. Albania has a commitment to improving access to legal aid by establishing a dedicated directorate. So we'd be interested in hearing more about your plans on implementing that and how Albania's national justice strategy is developing. Over to you, Minister.
Thank you so much, Mr. Powell. Dear colleagues, first of all, I'd like to express my appreciation for the Deputy Prime Minister and Minister of Justice of Latvia, Mr. Bordans, for organizing this event. I also would like to wish each of you in the respective countries a good job. My country, Albania, as I believe you are aware, has undertaken one of the deepest and most self-cleansing reforms in the field of justice, unique to most European countries and beyond the justice reform. Part of the legal package for the justice reform was also the new law, one state guaranteed legal aid. Previously, in my country, the concept of free legal aid didn't even exist. Today, with the help of the new law and the created mechanisms, we have accessed more than 95% of the territory guaranteeing the primary legal aid and almost 100% of the territory guaranteeing to our citizens the secondary legal aid. The biggest achievement, in my opinion, in the increase of trust among the citizens who, in case of need, do not remain without receiving the necessary legal services. All this confirmed by the date. Meanwhile, on the last 2 years, more than 11,200 individuals are beneficiaries of the primary legal aid, and more than 800 individuals are beneficiaries of the secondary legal aid. The legal aid mechanism was accompanied by a strong support of the Albanian government with a dedicated budget of about 600,000 euros per year, with the exception of the year where Albania was hit by the earthquake and the budget was reduced. While for 2022, the projected budget is about 700,000 euros, plus about 120,000 euros from other donors. In the service of the primary and secondary assistance function as service providers, 12 non-profit organizations with experience in legal matters, 11 law clinics at higher education institutions, 124 lawyers, and a green online number, as well as 10 relief service centers in the country's largest municipalities, offer their service in agreement with the Ministry of Justice or with the authorization of the Minister of Justice. This is our main challenge. Every citizen of the country must have the opportunity to be informed and legally represented regardless, despite of his economic opportunities. Of course, the digitalization of given aid, the creation of an integrated data system for the service provided, the improvement of the process of monitoring the standards of assistance given in order to increase the quality of service provided will also serve for this. I would like to thank you all for your time and patience. And last, I'd like to confirm and emphasize that Albania is fulfilling the commitments qualitatively and in a time. I wish you good proceedings of these sessions. Thank you. Thank you very much indeed.
Thank you very much, Minister. Thank you for that vision of ensuring legal aid regardless of income. Really inspiring. Let me now turn directly to Minister Salazar, Minister of Justice of Costa Rica, to explain to us a bit how you are using open government approaches to address your national justice priorities. Minister.
Muy buenos días. Saludos desde Costa Rica. Muchas gracias a quienes nos acompañan y muchísimas gracias a los organizadores de este momento para dialogar.
Thank you very much for the organizers for this event. In Costa Rica, we have been working not only for people, but with our citizens. So the approach that we're formulating involves working hand in hand with communities on prevention and inclusion, and also with regard to justice and the prison system. We have been working on strategies to prevent violence as well, working locally with the communities themselves so that the communities can explain their own difficulties with violence and propose solutions as well. The ideas of the communities and the ideas of government and the expert services so that we can reach agreement. The institutions, of course, go out into the field to also report back to the communities on the progress made with regard to implementation of those strategies. Our plan involves access to justice, and it's divided into 15 separate areas across the country, dealing with agreements for access to legal remedies and so on, alternative dispute mechanisms, working across a number of different domains, labor disputes, neighborhood disputes, and so on. We have also worked with young people, creating centers for peace, which are spaces where young boys and girls, young people can work on issues, can enjoy activities related to sport, art, science, and so on. All of these activities are aimed at reducing violence and including community members. We have a number of national institutions participating in this approach, and we have also set up a national center for peace where we work on interinstitutional decision-making, and we also assure reporting and accountability. With regard to the prison population, we provide support to people, providing alternative measures for fulfilling sentences, and providing these services across the country. In the pandemic, we started to organize a series of conferences as well to ensure that people had access to legal hearings and that people didn't lose touch with their own trials, with their own legal proceedings as a result of the pandemic. We have been working on violence with regard to prevention, and all of that information is on the website of the ministry. We have statistics that have been generated by the various institutions, and that is available to the entire population to consult. Thank you very much for giving us the opportunity of telling you a bit about what we are doing in Costa Rica.
Thank you so much, Minister, especially to bring in this element around inclusion and alternative means of accessing justice outside of the formal system. Really, really interesting work that you're leading. Let me now turn to the President of the Judiciary Council of Ecuador, Maria del Carmen Maldonado Sanchez, to talk a little bit about your justice strategy. Minister.
Good morning. It's a privilege to be in the second Dialogue of Justice Leaders, Transforming Justice for a Vibrant Social Contract, held by the Organization of Economic Development and Cooperation, OECD. I would like to thank the Upper Government Partnership for this invitation, in particular, its Deputy CEO, Joel Powell, the Ministry of Justice of Latvia, the Program of Peaceful Justice and Inclusive Societies, hosted by the Center of International Cooperation of the New York University and the Presidency of Ecuador as focal point of the OGP. My regards to all the ministers of justice and representatives of the all countries. This privilege of living in a democracy demands a commitment to cultivate and defend it. Transparency is one of the most powerful tools that reshapes how public institutions work by improving its capacity to answer the challenges of a complex society that is in search of an inclusive democracy. Two fundamental principles guide the judiciary, and every open government strategy has to take them account. One, access to justice. Two, independence. The Judicial Council of Ecuador, that I have the honor to preside as the first woman in Ecuador, approved the Open Justice Program this year. Three objectives guide this program. One, openness to the judiciary management by using information technologies, accountability, encouraging integrity and fighting corruption. Two, guarantee society's involvement in the decision-making process and establish mechanisms to monitor and control of this policy. Three, contribute to create collaborative spaces with different social actors in the design, assessment, and social control. The Judicial Council of Ecuador already accounts for some achievements, such as the Ethic Code, the monitoring of public contracts, accountability process, channels for reporting complaints, 100 transparency. The Open Justice Program takes into account these progresses and goes one step forward by implementing a specialized jurisdiction against corruption and organized crime that we already approve. Regarding people's participation and use the information technologies, I would like to present the electronic judiciary management system called Oecd. Also, Femicidios.easy, which contains not only statistics about femicides, but also other forms of violent deaths of women. It is also a dynamic system that monitors how ongoing trials relating to the matter and identifies potential delays. We consider that there are opportunities to go further in enhancing open government strategies in Ecuador judiciary, not only by implementing projects that are considered in our program, but also with the support of international cooperation. I would like to conclude by emphasizing that these initiatives are part of a democratic effort to bring the justice systems as the Lincoln's ideal, a government for the people, by the people, and with the people. Thank you very much. Saludos desde Ecuador.
Thank you so much, President Sanchez. I mean, amazed that you, in 3 minutes, could give us such a coherent strategic view of all the different elements of your work. Really, really inspiring to listen to. I'm now going to turn to Morocco. We have the Minister of Justice, Mr. Abdel Latif Wabi. In Morocco, in your new OGP plan, you actually have a commitment around making legal information more accessible and available to the public. Can you share some steps that you're taking on that reform and anything else you'd like to share with the group? Over to you, Minister.
Thank you very much, Mr. Chairman. Excellencies, Minister of Justice of the Republic of Latvia, Secretary General of the OECD, distinguished ministers, representative of the Open Government Partnership, distinguished participants. It's a great honor to be able to attend this second dialogue of judicial leaders on the citizens want fast and equitable justice and efficient justice. And this is why the issue of governance is key, of course. We need to make sure that we uphold the rights and freedoms of our citizens, and we need to do this by implementing a judicial system that's better focused on the people it intends to serve. Today, the judicial system is at a crossroads. There are different needs that we need to meet that are national and international, and we also have to meet the aspirations of our population who want their rights to be respected. Therefore, the founding principles of the current justice system have to guarantee the rights and freedoms of all our citizens. Ladies and gentlemen, the health crisis of COVID-19 has opened up new needs, in particular to better communicate with our citizens, and in particular with the bar. The bar has been a very key partner in order to ensure a proper reform of the legal system. Our department has been working in the area of legislation in order to promote programs that will meet the needs of our citizens and also hold our international commitments. We want to also work with our international partners, such as the OECD. We have a big reform plan to implement together with the ministry and a number of institutional and government partners. The idea is to facilitate access to information and to strengthen the efficiency of the legal services. At the same time, a bill has been presented on the technological tools that we can use. This bill doesn't just deal with shoring up legal aid, but also modernizing the whole of the Moroccan legal system. Ladies and gentlemen, a reform of the administration of justice has also been implemented since the law 5519 was implemented to simplify different procedures in order to establish a climate of trust in the link between institutions and citizens. And this is applying the principles of good judicial administration. This is Law 3113, with a right to access to information, which is a very important step. Article 27 of the Constitution ensures this right. The Ministry of Justice has committed to guarantee equitable access of all our citizens to information held by the legal administration through the person in charge of coordinating access and the deputy at the central administration, and as well at each jurisdiction, of course taking into account the separation of powers.
Thank you, Minister.
So finally, I can assure you, ladies and gentlemen, that the Kingdom of Morocco has committed vis-à-vis its international partners to do its best to make coherent efforts in order to meet these important objectives. And we are convinced that the values we uphold need to be fully implemented in order to ensure better access and equal access to justice for all of our citizens. Thank you very much.
Thank you so much, and for bringing in the vital role of access to information legislation as underpinning a lot of the efforts that we've heard from different countries on so far. I'm now going to move to North Macedonia, which has demonstrated a lot of leadership over the years on making the justice system more open and accessible. So over to you, Minister of Justice of North Macedonia, Mr. Bojan Maricic.
Thank you. Thank you, Mr. Powell, for your question. And of course, for the opportunity to address today's event. It's no coincidence that smart people have once said that justice delayed is justice denied, and that a country is as developed as it makes justice accessible to the marginalized groups. In order for the justice to be available to the marginalized groups, there is a tool in our laws called free legal assistance. It can be used primarily by those citizens who do not have enough financial means to cover court expenses by themselves. The state fully covers all court costs for them, even the cost for the expensive forensics. A large number of citizens used this tool. I would like to say that the court fees in North Macedonia in the past year have been reduced by 8 times, and now the amount is maximum of 100 euros per case. And we did this so that we can bring justice system to all citizens and make it more accessible than before. In your question, Mr. Powell mentioned also the Roma people in your in the concept. It is an interesting fact to be mentioned that the state secretary in our Ministry of Justice is a Roma person, which I consider to be our advantage. I would also mention that for this vulnerable group, we have done so much in the past several years, but I would particularly stress the law on unregistered persons. That law aims to reduce and to cut it to zero the number of people without personal documents that have not been registered in the civil registry. I would like to point out the importance of the principles of open government, transparency, civic participation, and public accountability to the justice system. These principles are not only important for courts, but also for the other actors that play a role in the delivery of justice services. As experience that I would like to share with you is that government and civil society must work together, and that gives good results for the reforms. If they work jointly with concrete commitments across a broad range of issues, and to provide an opportunity to make delivery of justice more transparent, participatory, inclusive, and to improve accessibility of justice institutions and services. North Macedonia continuously is working towards SDG 16 to promote peaceful and inclusive societies for sustainable development, to provide access to justice for all, and build effective, accountable, and inclusive institutions. North Macedonia is actively involved in the Open Government Partnership, committed to improving access to justice, greater openness of judicial institutions, and restoring citizens' trust in the judiciary. Active participation in the Council for Cooperation with Development and Civil Society is our priority. That is an advisory board of the government composed of the majority of the civil society actors. Furthermore, as part of OGP, the Judicial Council in June 2021 adopted an action plan for open judiciary between 21 and 23, with activities for improvement of the electronic court portal, improving the public relations of the courts, improving the quality and availability of data and information on functioning of the Judicial Council, strengthening the oversight activity of the judiciary, data quality, and improving the electronic system for initial and continuous training of judges, as well as monitoring the corruption in the judiciary with specific target groups, methods of monitoring, indicators, and timelines. As we are all affected by COVID-19, the government of North Macedonia remains dedicated in providing equal access to justice to all citizens and shifting services online, enabling digital transformation in our judiciaries. Justice is one of the fundamental attributes of a fair trial. The crisis only highlighted how important and inclusive digital services can be and how investments in information and communication technology will only increase the transparency, openness, efficiency, and by that make a significant impact on the access to justice as a faster and more cost-effective way to achieve an independent and impartial judiciary. To conclude, our efforts will not stop here. Digitalization of the judiciary remains one of our top priorities in the future. I am grateful that we have this opportunity for exchange of our experience and best practices in further strengthening of the transparency and openness of the judiciary that will have reflection on our reform processes in the future. Thank you for your attention, and it was my pleasure to participate at this conference.
Thank you very much, Minister Maricic, also for emphasizing the importance of government and civil society collaboration through all of these reforms. Also, just to acknowledge Commissioner Jureva, Deputy Secretary General Slagenhoff have joined us. Thank you. We're running a tad behind. We have 3 more countries to cover in this session, but we'll keep moving as swiftly as we can. So let me now turn to the Vice Minister of Justice for Armenia, Mr. Surin Grigorian. Over to you. The floor is yours. Mr. Grigorian, are you there?
Yeah, sorry. Can you hear me?
Yes, we can. Yep.
Thanks. Thanks, Mr. Powell. Before answering the question and the issue, I would like to thank Government of Latvia for hosting this virtual event and, of course, the partners, OECD, the Open Government Partnership, and the Pathfinders for Peaceful, Just, and Inclusive Societies. I'm honored to present the progress that Armenia has recorded within the previous years. As you're aware, the government of Armenia, along with the civil society organizations, is in the process of developing the 5th OGP National Action Plan. We are committed to creating an action plan that is more challenging than the previous one, as the 4th National Action Plan was highly inclusive and progressive. Armenia is currently in the process of implementing its 11 open government commitments, which include the implementation of the mechanisms that enable public engagement and participation in democratic processes. Moving to the activities conducted within the framework of our commitments, we are proud to announce the complete functioning of the e-draft, unified public electronic platform for publishing legislative drafts. Public access to the legal drafts ensures the direct participation of not only the civil society organizations, but also the citizens in the policy-making decisions and engagement in debates about social justice. Another reform vis-à-vis our open government commitments is establishing individual and collective petitions institutions in Armenia. This reform proved high efficiency during the pandemic crisis. It served as a guide for the government of Armenia, which was willing to discuss and change pandemic regulations in accordance with the citizens' needs. And finally, I would like to mention the disclosure of beneficial owners as one of the most ambitious and successful reforms. Now, the State Register of Legal Entities of Armenia is also registering beneficial ownership information. The register will eventually provide comprehensive information on beneficial owners of all entities acting in Armenia. It's worth noting Armenia is one of the first countries to publish data using the beneficial ownership data standard and open contracting data standard. Beyond that, we committed politically to be a member of the Beneficial Ownership Leadership Group and closely work with our governments on policy issues of this reform. I would also like to refer to the digitalization process that the primary justice-related databases are undergoing. We currently have functioning justice-related platforms such as eCivil, eRegister, eCompulsory, eCourt, and we are developing a few more platforms, in particular bankruptcy, criminal case, and so forth. The digitalization of these platforms will ensure transparency and easy monitoring and storing of the data. In the future, we aim to expand access to legal services beyond the formal institutions and broaden their focus beyond the courts to areas like policing and prisons. Thank you again. I wish you all a productive discussion.
Thank you very much, Vice Minister, and for bringing in this key issue on beneficial ownership and transparency over who owns and controls companies, which is obviously a key corruption issue that that has been accelerating in recent years. I'll now turn to the Vice Minister of Justice of Lithuania. That's Vice Minister Grigaitė Daugirdaitė. The floor is yours.
Thank you. Dear ministers and colleagues, I would like first of all to express my gratitude to the organizers of this second Global Dialogue of Justice Leaders, as this event is an excellent forum to share the political ideas how to achieve our common goal, and that is equal access to justice for all. One of the main goals of the Lithuanian government is to increase transparency, openness, and availability of justice institutions. And let me mention some of our national initiatives in this regard. First, modern technologies have already been introduced into judicial procedures in Lithuania since 2013. E-services portal of Lithuanian courts is widely used to communicate with our courts. And for example, last year, around 80% of civil and administrative cases were managed in electronic form. Furthermore, the use of video and teleconferences for organizing distant court hearings is constantly growing. And modern technologies have become even more relevant during the current COVID-19 pandemic because they allowed to continue the work of our courts without major interruptions. Currently, we are seeking for further progress and still having internal debates on how to tackle challenges related to the publicity of distant court hearings. We are looking for solutions that would allow not only to ensure effective public scrutiny of the proceedings, but also to protect basic human rights. Second, as from the 1st of September 2019, every person who seeks to defend constitutional rights or freedoms violated as a result of an unconstitutional law or other legal act may file an individual constitutional complaint to the Constitutional Court. The experience gained during the first 2 years of the operation of this new instrument shows that this additional possibility of persons to defend the rights has been very much needed and is being used actively. For example, in 2020, there were 231 individual claims filed to the Constitutional Court, and that accounts for 93% of all requests received by this court. Lastly, state-guaranteed legal aid is an essential component of the fundamental right to a fair trial. It plays an important role in addressing the legal needs of the most vulnerable members of the society who, due to their social situation, are unable to defend their rights properly. Despite the fact that practical adjustments had to be made in a rapid manner due to COVID-19 pandemic, state-guaranteed legal aid services were provided in Lithuania without delays and interruptions, using digital technologies or in-person communication when required. And from the beginning of the next year, e-platform for full administration of applications for state-guaranteed legal aid will be launched. So to conclude, I am really happy to fit luckily in these 2 minutes, and I'm really honored for this opportunity to share Lithuanian experience and looking forward to our further discussions. Thank you for the attention.
Thank you so much, Minister. Really interesting how you use those digital tools, and now some of them are continuing, which I'm sure is an experience many other countries have learned through this pandemic on how to reach citizens more effectively. Our final speaker in this session is the Assistant Deputy Minister of Justice for Canada, Elizabeth Eid. The floor is yours.
Thank you, Chair, and thank you to all distinguished participants today. Bonjour à tous et toutes.
Good afternoon to all.
I express the sincere regrets of the Minister of Justice of Canada for not being able to join us today. But I'd like to also acknowledge that I'm joining you today from my home office, which sits on the traditional territory of the Algonquin people. I would like to convey my deep thanks to Latvia as the host country and to the organizers for all their hard work to bring us together today. Today's discussion addresses the vital topic of how foundational open government principles can support justice systems to deliver people-focused justice and contribute to reinforcing democratic values, renewing our social contract, and supporting the well-being of all individuals and communities. These issues resonate deeply in Canada, as we have come to a fuller understanding of our country's colonial past and the harms that have resulted. We acknowledge that work that needs to be done. At the same time, we're confronting issues of systemic racism and discrimination within our institutions. And we have witnessed the disproportionate impact the pandemic has had on marginalized and underserved communities. Canada recognizes its responsibility to work with partners and civil society to address these deep fissures and inequities. A vibrant social contract can only be built on a foundation of trust, equality, and justice in partnership with communities. The government is committed to moving forward together on this journey and to achieve the vision of the 2030 Agenda to leave no one behind. Open government principles of transparency, accountability, empowerment, and inclusion all advance a people-focused approach to justice. Our efforts must be supported by data and evidence. In relation to the justice sector, building on a history of legal service, Canada has recently undertaken an ambitious legal needs survey of 30,000 individuals to understand the scope and the nature of people's problems and if and how they have taken steps to resolve these. The survey also includes a large sampling of Indigenous peoples. The ability to disaggregate the findings will allow us to better understand where efforts and resources are best deployed. Equally importantly, these results will be made available publicly for others to use for further research and policy development. Our commitment to transparency will be further evidenced as our upcoming National Action Plan on Open Government will include an open justice commitment, which has been co-developed with civil society. In our efforts to incorporate open government principles into our justice narrative, we have appreciated the support and learnings from the OGP Coalition on Justice. I also acknowledge and thank the OECD for its leadership in developing the people-centered justice framework and the good practice principles. This publication will serve as a foundational tool to countries and organizations seeking to place people at the heart of their justice responses. I thank you, and I thank you for sharing these developments from Canada. Merci.
Thank you so much. A really great ending to our second session. Those principles of trust, equality, and justice, I think you put it very nicely. That's the foundation for an effective and open justice system. As OGP, we obviously stand ready to support all of the countries here. And now it's my honor to pass the baton of moderation over to Alison Maynard Gibson, who many of you may know, twice the Attorney General and Minister for Legal Affairs of the Bahamas, a member of the Pathfinders Task Force, and a great inspiration and global leader on justice issues. Over to you, Alison.
Thank you, Joe, and good morning from the Bahamas. Good afternoon to those elsewhere in the world. I'd like to also join those who have thanked Latvia and the host countries and agencies for hosting this second global dialogue on justice ministers. We've heard about people-centered justice, we've heard about open government, and we're now moving to where we are today. We shall hear from justice ministers who will speak about the strengthening of the social contract, the increase in trust of injustice institutions, the importance of equal treatment to everyone, and how do we prevent tensions in society, especially by focusing on the understanding people's justice needs. That all of these underscore the importance of justice ministers being here today. I would invite those who have not, who are about to speak, if you've not actually clicked your communication, you choose your language, please, it'll be appreciated. And I will move straight on to, as we respect time, the Honorable Delroy Chuck, the Minister of Justice in Jamaica. Minister, as a fellow person from the same region, we look forward to hearing what you say in this arena. Welcome.
Thank you very much, and good day. It's now morning in Jamaica, but good day to all who are on the platform. May I thank you for inviting Jamaica to speak on the justice program here. And as our leader would indicate, we are part of the British system of justice. We do believe in the strict separation of powers, in that our courts, they guard their independence with great stress. They're always emphasized that they have to keep the executive and the legislature on their toes. It is fully committed to the rule of law and to uphold all constitutional issues in favor of balancing rights and responsibilities. Our major problem in our justice sector is that although justice is readily accessible, the timely delivery of justice is a major problem. Cases, once they start in a court, usually take many months, years for resolution. At the present time, the average period for a trial in the criminal courts is anywhere between 3 and 6 years. In the civil courts, we are now setting trial dates in 2026 and 2027. Now, when this happens, the citizens are losing trust and faith in delivering and resolving disputes. Here as Minister of Justice, even though we have given a great deal of resources and support to the justice sector, we now need to look at other means by which we can improve the timely delivery of justice so that the citizens can feel that having access the court system, they can get resolution of their matters in a reasonable time. That is why I am now emphasizing alternative dispute resolution in the criminal courts. We're promoting restorative justice. That is to get the victims and the offenders to meet outside the court system itself to try to resolve their matters. In the civil courts, we're using mediation, encouraging all the parties, please try and come together to see if you can settle matters, because in mediation, you have a win-win situation. And if you leave it to the courts, your problem is it's a win-lose. And oftentimes it's a lose-lose situation because it takes so long for the matter to be resolved. I just want to say, as you circulate the information, I would be very happy if we get information how best we can deliver justice on a timely manner. Thank you very much for having Jamaica on the platform.
Thank you, Minister, for letting us see what is happening in Jamaica, and also welcoming your colleagues to share information with you as you are also sharing with them. It's now my pleasure to welcome to the speaker, to speak, Sander Dekker, the Minister of Legal Protection of the Netherlands.
Thank you, Alison. And please let me start by thanking the organizers for this opportunity to reflect on how the Netherlands has addressed and will continue to address SDG 16, equal access to justice. Today, I'd like to discuss two main elements of this session: the essence of the rule of law and the importance of people-centered justice. But let me start by the rule of law. The rule of law is the center of our democratic constitutional state. But what exactly does that mean? Well, it starts with the basic principles of human dignity. Everyone deserves to be treated equally. The law is therefore for everyone. Everyone should have equal access to justice, and the government should be the first to abide by the law. It's the essence of the rule of law, based on legislation and strong independent institutions that provide checks and balances. Despite the differences between our legal systems, we should guarantee that our fundamental values are upheld, and that should not be up for negotiation. The independence of the judiciary guarantees citizens fundamental rights and prevents abuse of power. And it provides legal certainty, granting the stable condition for wealth and well-being. Yet, strong institutions alone don't guarantee equal access to justice. So let me come to my second point. Access to justice is about meeting people's needs and helping them to resolve their problems. It's about the practical meaning of the rule of law on people's daily lives. And we must strive for people-centered justice, removing barriers so the rule of law means something in their real lives. And too often, court decisions don't address the underlying causes that led to legal proceedings. For access to justice to be effective, people must be able to find lasting solutions to the problems that they face. With that in mind, the Dutch government is working hard to make justice more accessible. For example, we aim to decrease the social and physical conditions between citizens and the justice sector by introducing several initiatives such as problem-solving courts, youth courts, and community courts. People often face multiple interrelated problems. Think of example about financial debts that keep accumulating. Addressing them together ensures that the problem is tackled in its entirety. A problem often does not stop after a court judgment. So access to justice is more than access to a judge. We must aim higher. Therefore, we have introduced a unified local approach. Social workers on the one hand and lawyers on the other come together to help people explore the underlying issues. And it's an approach that prevents future problems legally or otherwise. So strong, independent institutions and a people-centered justice approach are indispensable to improve the rule of law, increase trust, and prevent and solve tensions in society. Thank you so much.
Thank you, Minister, for your succinct and fulsome presentation. Much appreciated. And now we have the pleasure to move to another region of the world, and that is Africa, Liberia, another part of the world. So we invite the Assistant Minister for Codification at the Ministry of Justice of Liberia, Abraham Mitchell, to make his contribution, please.
Thank you very much. Are you getting me?
We can hear you clearly. Please go ahead and welcome.
Oh, thank you very much. Well, on behalf of the Minister of Justice and the Attorney General of the Republic of Liberia, Frank Musa Dane Jr., I am very pleased and privileged to represent him and the government of Liberia at these very important discussions. We'd like to thank the host government and the Ministry of Justice of Latvia for the second edition of the Global Dialogue of Justice Leaders in cooperation with the OECD and the OGP, the partners and peaceful and others, justice and inclusion also like to thank all other distinguished colleagues for time to converge globally for these very important dialogues of Justice Actor. Secondly, Liberia is very delighted to be considered for participation and to bring some perspectives to the discussion. This section calls for reflection on access to justice in the context of reinforcing democracy, reimagining the rule.
I don't know. I think we may have lost the minister. Are we still there? Okay, I see in the chat that the minister is no longer connected to us, and perhaps if he reconnects, we can come back to him. So then, could we move on to the Ambassador and Permanent Representative of Australia, Brendan Pearson? And might I ask our technological team, please, so if the Minister of Liberia comes back on, we can also slot him back in, please.
Thank you very much. And I join you from Paris, and I'm representing today Australia's Attorney General, who unfortunately can't be here because it's probably about 2:30 in the morning in Australia. So, and I wanted to talk to the issue of access to justice in an area where we all are confronting problems, and that is, and we're working out, we've come upon one solution to the problem of online trolling, because that is an issue that very many of our citizens are confronting. But up until now, we've had very little we could do about it. This is on social media. It's a problem that in Australia affects thousands of people every day. It has a very, very adverse impact on many of them. But until now, we've had no solution or no way to provide justice for those people who are targeted by this a different type of pandemic. So, you know, we all know that, in our case, we all know that social media can be a form of a coward's castle where bullies can attack and defame fellow citizens behind a virtual firewall of anonymity. So, as I said, the reputations can be ruined by this, victims can be badly damaged, and even there have been many occasions of an unfortunate resort to suicide. So the Attorney General in Australia is taking a two-pronged approach to this problem. Firstly, we are going to require social media companies to develop a simple, quick and standardised complaint system, and that will enable, and one of the requirements of that system will be to enable defamatory remarks or to be removed and the trolls identified with their consent. As long if they don't remove the remarks, then we move to part 2 solution, and we're going to establish a new federal court order to force social media giants to disclose identifying details of trolls without their consent to enable defamation proceedings to be lodged. So these two solutions are new. We hope to legislate them in the early part of next year, and they build on a number of measures taken by the government on e-safety over the recent years, which were largely very influenced by the OECD's Riga statement agreed in Latvia in July 2018. Thank you for your attention.
Thank you very much, and thank you for bringing to our attention, and please do keep us all updated on the measures that are being taken that you've just elucidated. They are major, and so the extent to which we can all learn from your experience will be very, very helpful. Minister from Liberia, we welcome you back. I see that the technical people are advising that you might want to turn off your camera to enhance your the strength of your connection. But it's up to you. Would you proceed, please, Minister?
Yes, ma'am. Thank you very much.
Thank you, Minister.
Yeah. So I was trying to illustrate that as access to justice, we thought that in Liberia as a strategy and a way forward, we integrate our justice and security program within our national development agenda. So the Pro-Poor agenda, which is the national development strategy of Liberia, has Pillar 3 exclusively set aside to deal with justice, security, and rule of law issues. Specifically in the Ministry of Justice, I would like to acquaint colleagues with some of the achievements we've made in our delivery of justice and security services. Firstly, as a post-conflict country, we developed what we called a hub concept, justice and security hub concept, established on a regional basis that integrates various sub-political divisions. And then we harness our justice and security and social services into these in a proximity way and cost-effective way to provide justice and security services to our people regionally. The other thing we have done also, health pandemic has become a major justice security issue in Liberia by virtue of our own experience. We had our experience with Ebola, and now the COVID-19. So for that purpose,
we seem to have lost the minister again. Technical team. Should we just continue our technical team? Okay. And hopefully he'll be back on soon. We've had a session that has been very, very interesting, very, very productive. And I want to thank all of the ministers for their inspiring interventions. Before we move on, might I ask that we all pause to allow the technical team, albeit virtually, to take a photograph, please. Big smiles. Okay, thank you very much. The result of this morning is that we all have been able at the second forum to see that there really is a need to transform justice and to reinforce the principles that put people at the center for a vibrant social contract, which we are aware is under pressure. The meeting is taking place for a second time, and in health and education, there are established global structures for ministers and other leaders to gather. We don't yet have that in the justice sector, but we see that with a meeting like this and the movement for people-centered justice, places like this prove very, very productive and important and fruitful for ministers of justice to come together and to discuss issues of common interest. So again, we thank the host for this meeting. And I want to invite you all to come to the World Justice Forum in The Hague in June of 2022. This will be the next opportunity for productive conversation, and hopefully it can be in person. Those who want to help lead the work on people-centered justice are invited to join the Justice Action Coalition that is being set up by the Pathfinders under the leadership of the Netherlands. I take this time now to hand over to the Jānis Bordans, the Minister of Justice and Deputy Prime Minister of Latvia, our host. Minister, please, over to you.
Oh, thank you. Thank you very much. And now it is my true honor and great pleasure to invite our colleague, Ms. Vera Jourova, Commissioner for Values and Transparency, Vice President of the European Commission, to say some words in the conclusion of our discussion. Ms. Jourova, your contribution to the strengthening our fundamental rights and access to justice is invaluable, and please let me share the sincere gratitude to you for the possibility to be present in our debate today.
Yes, thank you very much, Mr. Minister. I also want to thank from my side for inviting. The pleasure is mine. I want to thank OECD and Latvia for giving me a chance to make together with you this fascinating tour across around globe, because I was listening for some time and it's really very inspirative. And I worked 5 years as Justice Commissioner of the EU in the previous mandate, so this topic is so close to my heart. We speak about a vibrant social contract and the necessity to renew trust. This is exactly what the people are telling us during the conference on the future of Europe, which is a big endeavor which we opened as a very broad public debate. For instance, we have the digital platform with already 4 million contributions, and you would maybe believe that the request for well-functioning justice system belongs to the most prominent topics and requests there. So this is a very, very clear feedback from the people. Also from what we hear from Europeans is that they suffer from the feeling of injustice and lack of security. And to renew the trust, we have to show that the institutions, especially the judiciary institutions, are able to deliver justice, and that our states can guarantee security to the citizens. So this is a very, very pertinent and important topic we are discussing today. I want to say a few words about the European Union, which is promoting modernization and digitalization of justice. Because I don't believe that the 21st century people should be provided with 19th century method of delivering justice. So we want to modernize judiciary. We adopted the Union strategy for the so-called digital decade, which is the framework for our digital transition to promote a human-centered, inclusive, secure, and open digital environment where digital technologies and services respect and enhance the Union's principles and values. So this is very much connected also with the more detailed plan to digitalize judiciary and security area. What we saw already before the pandemic, what some of you mentioned, that we are slow in delivering decisions. So we believe that the digitalization can play an important role in facilitating access to justice and also speed up the processes. Technology also helps us build stronger and more inclusive society. Digital solutions, for instance, can directly benefit persons with disabilities and victims of crime. At the same time, digitalization should not come at the expense of those who may lack the requisite technical means or digital skills. In Europe's digital transition, no one should be left behind. Digitalization offers us a perfect venue to implement the principles of an open government, transparency, openness, civic participation, and public accountability. Public online access to judicial decisions, electronic petition and public consultation platforms, automated systems for fair and unbiased allocation of court cases, and digitalization of public registers are but a few examples of how technology can strengthen our core principles and values. When it comes to the state of digitalization of justice in our member states, we have the annual assessment, the so-called EU Justice Scoreboard, and today's edition demonstrates that while significant progress has been already achieved, the overall landscape remains fragmented. A lot more needs to be done. That's why we believe that the recovery money, you know that in Europe we collected a lot of funding for the period post-pandemic, which also includes minimum 20% of all funding going to digitalization. So we believe that with this money, we can decrease the gaps between the member states. We want to improve also the fight against crime. As we all know, crime does not respect any borders, and in particular in cross-border criminal and terrorism investigations, time is of the essence. And we seek to tackle practical barriers to access to justice by enabling our citizens and businesses to use electronic instead of paper-based means of communication. Our digitalization proposal also lays down common rules on the use of video conferencing while safeguarding procedural rights. The Commission supports member states in improving the effectiveness of their national justice systems through different tools. And for the sake of the time, I will not go into the tools. One of them is the EU Justice Scoreboard, and of course also very streamlined funding, which is, I think, unique because I don't remember such a massive financial support from the EU to the member states to modernize their justice systems. Maybe the Latvian minister will confirm that there was never such a intense financial support for the member states to establish justice system as the modern public service with the enabled access to all. I want to finally mention, because the Dutch minister spoke about the rule of law as a founding principle of the EU. Indeed, we have some problems in several member states, some bad surprises where the rule of law principles are not fully respected. So we had to deploy new tools, and one of them is the annual rule of law report, which we issue every year as a preventive tool to help the member states to keep and respect the rule of law principles with the support of the EU. And we do this annual mapping of the situation of all the member states in a very inclusive way. We are inviting all important actors, of course, the member states, the ministries of justice, other relevant ministries, but also courts, prosecutors, lawyers, and other legal professions, and the civil society to help to obtain objective mapping of the situation in the rule of law sphere in the member states. I am skipping some of the parts of my prepared contribution because I know we are delayed. So I just wanted to tell you that it is fascinating to have this debate because we hear the same or very similar issues to be addressed on all covered continents in our debate today, and that it's so important that we try to also look for efficient and functioning solutions together in cooperation. Thank you for this opportunity, and thank you for attention.
Thank you so much. And I urge those who are in attendance to please stay connected. We're not going to be too much longer. We're going to respect time going forward. And I'm straight back to you, Minister of Justice of Latvia, and I invite you to bring your closing remarks, please.
Thank you very much. And my sincere gratitude to Ms. Jourova for your presence and mentioning the important elements related to the people centricity elaborated in the framework of the European Union. That's very important. And I would like to thank moderators, Ms. Maynard Gibson, Mr. Powell, and all the speakers taking the floor today for your excellent contributions, colleagues around the world following the debate, and for being with us. Please let me extend sincere gratitude to all and everyone engaged in the planning of the event, to OECD, Pathfinders for Peaceful and Just and Inclusive Societies and Open Government Partnership. I trust that the important elements we have touched today will contribute to shaping the global justice policy debate in the coming years. As I indicated at the beginning of the event, one of the goals of this high-level dialogue is that leaders can agree on an outcome document that can help to shape the justice policy debate in the coming years. I am pleased that we have agreed on the Riga Justice Agenda, which is available online on the link shared in the chat. Some of the key messages from the Riga Agenda are the following. First, we need to work toward transformation of justice system. The mentioned transformation needs to be grounded and supported by data and legal needs, strategies, modern management approach, and capacity building. The open governance principles to be integrated in justice system. Collaborative work at the different levels to be enhanced, engaging civil society and other stakeholders. Further efforts are needed to enhance people centricity, resolve justice problems, improve justice journeys, use justice for prevention and to promote reconciliation, empower people to access services and opportunities. Thank you. I would like to thank sincerely one more time our partners, and please let me give the floor to Deputy Secretary General of OECD, Mr. Jeffrey Schlangenhoff.
Thank you very much. Dear ministers, distinguished participants, we heard a message today loud and clear. Bringing justice closer to the people at this historical juncture has the potential to underpin an inclusive and sustainable recovery from the COVID-19 crisis. It strengthens democratic governance, in particular the rule of law, which is an important objective of the Initiative on Reinforcing Democracy launched by the OECD Public Governance Committee this year. This is why I'm pleased to see such a strong outcome of today's dialogue in the Riga Justice Agenda on transforming justice for a vibrant social contract. In particular, I'd like to highlight three important takeaways from the discussion. First, we've heard calls for an ambitious effort to put people and their justice needs at the center of justice systems. We hope that the OECD framework and good practice principles on people-centered justice presented here today will be a useful tool to support progress towards this goal. Building on the framework, the OECD will continue to develop instruments and guidance in order to tailor justice policies towards citizens' legal needs and make use of technological innovation to maximize access to justice. Second, participants have emphasized that justice transformation should be grounded in data on justice needs and structural injustices in order to make systems more responsive. Through its evidence-based approach to justice policymaking, the OECD will continue to support you with tools such as the Legal Needs Survey methodology and the module to report on SDG Indicator 16.3.3 on access to justice and good practices from around the world. Lastly, the exchange has highlighted that learning from each other, measuring progress, and being accountable to the people will be crucial. The OECD stands ready to support you as a platform for international exchange, including through our global access to justice roundtables, as well as through tailored country support. I take this opportunity to reiterate our gratitude to the Ministry of Justice of Latvia, the Open Government Partnership, and the Pathfinders for Peaceful, Just, and Inclusive Societies for the collaboration organizing this dialogue. And to all participating leaders, I wish you further future discussions for the rest of the Global Week, and thank you for your attention and the opportunity to join you today. The floor is back to you.
Thank you very much. And let me say that as we wrap up this session, that we wish each other a successful rest of the Global Week. And I, again, encourage everybody to register and to attend the World Justice Forum in 2022 in The Hague. Thank you again, our hosts, and thank you everybody for staying connected and for sharing your views and engaging so actively in this important dialogue. I wish you all a successful conference and the rest of the day. Thank you very much.
Yeah.